Vice Chair Fraser, we will do House File 1406. Would you like to move to recommend that House File 1406 be re-referred to the Ways and Means Committee?
That is my motion, Madam Chair.
All right. The bill is now before us. Please tell us about your bill.
Madam Chair and members, House File 1406 seeks to reform our felony murder aiding and abetting law. Currently in Minnesota, people can be charged with and convicted of murder even though they did not kill anyone nor intend for anyone to die or anticipate that that death would occur. This is because of our aiding and abetting homicide laws. In 2021, a legislative task force, including county attorneys, police chiefs, victim advocates, impacted people, public defenders, and other experts examined Minnesota's aiding and abetting felony murder doctrine, compared it to other states, and looked at patterns on who is charged and punished under the doctrine. What they learned was the impact of our current law has been uneven. It disproportionately impacts young people, women, and people of color. 56% of those charged are under the age of 25, 48% charged are black, 80% of those convicted are people of color, and the majority of those impacted have little or no criminal history. In short, this law has a significant and disproportional life-changing impact on certain populations of our state. House File 46 is a result of the work of the task force, and House File 46 will put the recommendations of the work of the task force into law. Those recommendations are as follows: revising relevant statutes such as those who aid and abet felonies are not liable for murder where the aider and abetter did not A, kill another, B, otherwise contribute to the homicidal acts of another while intending to kill, nor act with reckless disregard for human life as a major participant in a felony where a human died. Also, revise relevant statutes such that people previously convicted of aiding and abetting felony murder may petition the court for release. Also, implementing reforms beyond mere adoption of an affirmative defense for aiding and abetting felony murder. And then also expanding the task force mandate and timeline to undertake similar work as it applies to Minnesota's felony murder doctrine and or aiding and abetting liability generally. I do have one member of the task force here to help with any questions if needed. And I would like to thank Chair Kelly Moeller for the work that she's done on this over the years. It's been a work in progress, but it has been with bipartisan support. The Senate bill is moving with bipartisan support, and I expect that this bill will have bipartisan support as it has in the past. Madam Chair, I'll stand for questions.
All right. Thank you, Vice Chair Fraser. Are there any other members of the public wishing to testify on this bill? All right. Not seeing any, we'll move on to member discussion. Representative Johnson.
Chair Becker-Finn, Representative Fraser. In the bill, I see there's a, where was that? Where a person already convicted of aiding and abetting can go back and revisit it. Can you explain how that works?
Vice Chair Fraser.
Thank you, Madam Chair. Once this bill is put into law, an individual that is currently incarcerated for aiding and abetting would be able to petition to the court to have their matter reviewed to see if it falls under the new standards for felony murder, aiding and abetting. And if it is determined that it is, they will sentence and charges and convictions will be adjusted accordingly.
Representative Johnson.
Chair Becker-Finn, Representative Fraser, thank you for that explanation. Next question I have dealing with that, if they look back, they were charged under different elements of the crime. If they look back at the court records, some of those elements might not even been looked at. With these changes in element that they have to prove, are they going to have a new trial or try to figure out if the elements of the crime they just happened in the case to see the elements of the crime that they had?
I do have some of the folks that helped draft this language that were part of the task force, a couple of attorneys here, that this is their Billy Wick. Representative Johnson, could you repeat the, Madam Chair?
Yeah, no, it's fine. Yeah, Representative Johnson, if you could repeat the question while the other testifiers here are listening to you.
Looking at the Chair Becker-Finn, Representative Fraser, and the testifiers, looking at the bill, the elements of the crime that they were convicted of is different than the new elements of the crime because it changed things. They might not have looked at, or in the court trial, even looked at these elements. Is that going to create where just about everyone has to have a new trial?
Go ahead and introduce yourself for the record, and then go
Hello.
ahead with your answer.
My name is Perry Moriarty. I'm a law professor at the University of Minnesota, and I was a member of the task force, and my apologies for just now arriving. We're not anticipating, Representative Johnson, that there would be a need for a new trial. I may be slightly misunderstanding the question. In terms of the convictions themselves, many of them, of course, are for aiding and abetting felony murder, either first or second degree. They're pleas to, within this group, they're pleas to other offenses as well. But the anticipation is that we'll go back, and there are very specific, detailed criteria about what would trigger another look and perhaps a re-examination of the conviction. And it would depend, of course, on whether or not the applicants or petitioners could meet the elements laid out in the bill. And so there'd be a rigorous review of both the application and presumably of the trial record itself, but we're not anticipating a need for a new trial.
Representative Johnson.
Chair Becker Finn, Representative Frazier, and the testifier. That's the point. In that trial, these elements weren't there. Would they have even looked at these elements? Now you're having to go through and do you might have to do a whole new investigation because looking for these elements. When an officer does the investigation, they're looking at the elements of the crime, they're getting as much detail as possible. And in the court hearing, it's where they go through the elements. Now you've changed the elements, and it could cause some issues.
Response, Professor Moriarty.
Chair Becker Finn, thank you. And thank you, Representative Johnson. I'm sorry, I wasn't sure I understood the question the first time around. I mean, and there are county attorneys here who may be able to speak to this even better than I, having not been a county attorney. But presumably, all of the evidence that supported the initial conviction was brought forward and was investigated. The question really is whether our laws, as applied, even under those circumstances, were fair and were actually yielding convictions and sentences that were proportional. So I don't believe that there's concern that the evidence would not have been unearthed or investigated to begin with. I think the real question is, as enforced, were the laws necessarily meeting the right convictions and the right sentences for the right people? Or were there people that had lesser roles and really didn't have an opportunity under our laws to be held accountable for those lesser roles because of the way the laws have operated? And I believe that's how, one thing I might add is that, this has happened in a number of other states. In particular in California, I think there are many more people who fall under these laws and the retroactivity provisions, and I'm not aware of any new trials. I'm aware of a reassessment of the overall culpability of the actors.
Representative Johnson.
Chair Becker Finn and to the testifier. I'm not sure if this retroactive part fits the same as California, but I know what this says. And when you go to appeal a case or something, you don't look at new evidence, you look at what was in the courts, what was done during the court hearing. Mm-hmm. There might be stuff in the reports and stuff that meet these elements, but if they weren't used in court, they couldn't be used in the appeal process.
Vice Chair Frazier.
Thank you, Madam Chair. Representative Johnson, the idea of this is that with the retroactivity piece is to give individuals that were charged under the current statutes that we have now the ability to go back through this petition process to look at the facts of that case. And if you apply the facts to the new standards and they find that that individual was not a major participant or did not actually participate in the cause of a death in the carrying out of this felony, then there will be an adjustment based on that. And that decision can be made based on the evidence that is already in the record, because presumably that evidence would have been provided to the prosecution in order to make that initial charge and take that case to trial and present that evidence, or to give that initial charge, and then often, in most cases, lead to a plea agreement. So the evidence will be there. It will be the same evidence. It'll just be applied under these different standards.
Final follow-up, Representative Johnson.
Chair Becker Finn, Representative Frazier, I understand what you're saying, but I've been in court and understand the appeals process as well. But in the appeals process, looking at the retroactivity, they only can use the evidence that was entered into court. With different elements being used for the crime, there's no guarantee that the elements were actually used in court to actually use the records. That's my problem with the retroactivity. I guess maybe at some point we just have to agree to disagree on this one, but that's the concerns I have.
Representative Scott.
Madam Chair, are we not doing the DE? I'm just curious.
Vice Chair Frazier.
We're not doing the DE. So the DE would align this bill with the Senate. There were some changes made. Many of those changes we do like and we accept, but there are some pieces that we want to iron out some language on. So we're gonna take care of it in conference committee.
Okay, thanks for that clarification.
Further discussion to the bill. All right, closing comments, Vice Chair Frazier.
Thank you, Madam Chair. Thank you, members, for the questions. Representative Johnson, I think we can talk more, because I think we do. I think there is an answer and an understanding we can get to as to how that part works, and I think we can talk more about that. I think you've been a little bit I think you've been supportive of this in the past. Am I remembering that right?
Representative Johnson.
You know, Chair Becker Finn, I think there was some things I did, but in the past it needed quite a bit of tweaking.
Yeah, and I know in the past we have had Republican co-authors of this bill on the House side as well. So, Vice Chair Frazier.
Thank you, Madam Chair. Representative Johnson, I'm going to get you there. We'll get there. Appreciate the honesty. This is time. Most countries have abolished this doctrine. Almost all 50 states within our country are moving in a way to do some revisions to this, so that we are getting the folks that are most culpable for these crimes when they're committed. And it's time for Minnesota to move in that direction. So I would appreciate the support of the members.
All right, we'll renew Vice Chair Frazier's motion to recommend that House File 1406 be re-referred to the Ways and Means Committee. All those in favor, please say aye. Aye. Opposed? The motion prevails. Thank you, Vice Chair Frazier.